英文 testing 1 2 3 4。英文 testing 1 2 3。英文 testing 1 2 3 4。英文 testing 1 2 3。英文 testing 1 2 3 4。英文 testing 1 2 3。
Good morning, ladies and gentlemen. Welcome to Legal Week 2024. The Asia Pacific International Private Law Summit 2024 is going to commence shortly. Please kindly be seated. A gentle reminder, please switch your mobile phone into silent mode, and the event will be conducted in English with simultaneous interpretations in Cantonese and Putonghua. You can pick up an SI headset at the entrance of this hall, channel 1 for English, channel 2 for Cantonese, and channel 3 for Putonghua. For online participants, you may choose your preferred language by clicking the language button at the bottom of your screen. The QR codes about today's programs are placed around the hall, and you can view the biographies of our speakers today. 各位來賓，大家早晨。香港法律週2024亞太國際司法峰會即將開始，有請各位盡快就座，並且將你哋嘅手提電話調至靜音模式。今日嘅會議將會以英語進行，並且設有粵語同埋普通話嘅即時傳譯服務。各位可以喺入口嘅位置領取即時傳譯耳機，頻道1為英語，頻道2為粵語，頻道3係普通話。網上嘅參加者可以點擊直播畫面下面嘅語言按鈕選擇語言。另外，場內亦都設有二維碼，掃描之後可以睇到今日嘅節目安排同埋講者嘅簡歷。各位來賓，大家早安！香港法律週2024亞太國際司法峰會即將開始，有請各位盡快入座，並把你們的手提電話調至靜音模式。今天的會議會以英語進行，並設有粵語還有普通話的即時傳譯服務。各位可以在入口領取同聲傳譯耳機，頻道1是英語，頻道2是粵語，頻道3是普通話。網上的觀眾可以點擊直播畫面下方的語言按鈕選擇語言。另外，場內也設有二維碼，掃描之後可以查看一下今天活動的安排，還有了解講者的履歷。謝謝。 Ladies and gentlemen, our summit will commence shortly. Please be seated. Thank you very much. 各位來賓，我哋嘅會議咧馬上就會開始，有請各位盡快就座。各位來賓，我們的會議馬上開始，有請各位盡快入座，謝謝大家。Commissioner Choi, Secretary Lam, Professor Terrados, Your Excellencies, Consul Generals, distinguished guests, ladies and gentlemen, good morning. Welcome to the first event of Hong Kong Legal Week 2024, the Asia Pacific International Private Law Summit 2024, co-organized by the International Institute for the Unification of Private Law, UNITRA, and the Department of Justice of the Hong Kong SAR. Thank you very much for joining us here in person and online. My name is Xavier Yao, and it is my absolute pleasure to be your MC for today. And to kick off today's conference, we're honored to have three distinguished speakers delivering their welcoming remarks. So now, ladies and gentlemen, let's give a big round of applause and welcome Mr. Cui Jianchun, Commissioner of the Ministry of Foreign Affairs of the People's Republic of China in the Hong Kong SAR, to come up on stage to deliver his welcoming remarks. Mr. Cui, please.
Secretary Paul Lendingguo, Secretary General Ignacio Tirado, Honorable Consul Generals, dear guests, friends online and offline, ladies and gentlemen, a big good morning. It gives me great pleasure to attend the Asian Pacific International Private Law Summit and to jointly kick off Hong Kong Legal Week 2024 with all of you. I would like to share my feeling about this private law summit and also Hong Kong Legal Week. In my understanding and my observation, the law is of the paramount importance for every society and every country. And we believe law is one of the four pillars: democracy, market economy, civil society, and the rule of law. Hong Kong, the legal week, is really paving the way not only for Hong Kongers, for the people in mainland, and also for the international community. We believe here that every people can make free decision within the private law and the public law. The same for this year's legal week is Hong Kong common law system. I just noticed that Hong Kong common law is a springboard to China, beyond China, to the international community. This we think that Hong Kong has unique strengths. I just share my idea with the Secretary for Justice. The strength of law is the strength of Hong Kong. And the same for this year's Legal Week is Hong Kong Common Law System, a world-class springboard to China and beyond, which points to Hong Kong's unique strengths and highlights the importance of the one country, two system principle. On behalf of the Commissioner's Office of China's Foreign Ministry of Hong Kong, I would like to extend my warm congratulations on the opening of a Legal Week and the convening of the summit. Ladies and gentlemen, we are in an era where both great opportunities and challenges exist. I do believe everybody recognizes we are in the era of change. If to describe this era with one word, I think it should be change. Our summit today will discuss a wide range of topics, including digital assets, tokens, carbon credits, international investment, and sustainable development. It highlights necessity for international rules to change and evolve alongside technological advancement. In the new era, China, okay, sorry. In the new, this is not Chinese technology. In the new era, China has been consistently innovating its diplomatic ideas to make great governance and international law fairer and more equitable. First, we uphold sovereign equality, and advocate for an equal and orderly multipolar world. If the trend towards global multipolarity marks a significant historical shift, which emerging and developing countries surpassing developed countries in GDP share, now reaching 59.83%. The global south is rising, and fairness, justice, and win-win cooperation are increasingly becoming the common pursuit of the international community. China stands firm on true multilateralism and believes that all nations, regardless of size or strength, should participate equally in this multipolar process. With this belief, we foster consensus through platforms like the Forum of China-Africa Cooperation and the BRIC Summit, and make joint efforts with countries around the world to address global challenges. Second, we uphold mutual benefits and advocate for inclusive economic globalization. Economic globalization is an irreversible trend. All countries, classes, and groups should equally share the outcomes of economic and social development. This year, China's economy has shown an encouraging momentum of stability and growth. I want to let you know 5% GDP growth rate, the whole mainland China, we are working towards this goal. We are confident that we can achieve this very, very important indicator, because without growth rate, we cannot create jobs. We cannot have a stable society. So This growth will contributing to not only for China and contributing to global recovery. Also, China actively maintains the stability of global industrial and supply chains and work for a fairer international trade system. China has signed over 200 cooperation documents under the Belt and Road Initiative with more than 154 countries and 39 international organizations, resulting in over 3,000 cooperative projects. I do believe you will recognize the BRI is not only a platform, not only the principle, not only the policy and the program and the project. I believe that we have delivered a tangible result of the year 2013, this proposal proposed by Chinese President Xi Jinping. So now China is working with 154 countries to try to carry out extensive consultation and joint contribution and shared benefits. And I do believe that in the coming 10 years, 15 years, especially by the year 2049, the founding of a new China, when we celebrate the 100 years anniversary of founding of a new China, I do believe that we can make a quantum leap, not only for China's the happiness of people, and most important for the progress of humankind. As the window of China's high standard opening up, Hong Kong helps countries worldwide to share China's development dividend. We believe Hong Kong's uniqueness, not only serving and linking mainland with international community, and we believe here the common law, the unique law system can pave the way for the development of international community. The third, we uphold fairness and justice and advocate for the rule of law in global governance. I want to let you know that Hong Kong, the society, the Hong Kongers, we are free to make our decision. That means we are not subject to the rule or control of other side. So I congratulate especially the national security law and the safeguarding national security ordinance in Hong Kong. So people enjoy our freedom, we are free, and also we have a high degree of autonomy. We firmly protect international order based on international law and contribute our share to enhancing fairness and transparency of multilateral mechanisms and fostering a global governance model featuring extensive consultation, joint contribution, and shared benefits. China promotes the development of governance. We believe governance is really a very, very important element or factor for every nation's development. The government roles in emerging areas such as oceans, polar regions, digital currencies, artificial intelligence, climate change, and public health. We support the role of multilateral legal organizations like the International Institute for the Unification of Private Law and the Hague Conference on Private International Law. Our aim is to strengthen the coordination of international rules and ensure the equal application of international law to make global governance better. I do hope we should have a consensus. The global governance, we are facing the serious challenge. So today is very meaningful for everybody to take part in this kind of summit to discuss of global governance, national governance, governance of society. Dear guests and friends, in a changing international landscape, the third plenum of the 20th Central Committee of the Communist Party of China has made strategic decisions to deepen reforms and advance Chinese modernization. In China, we value reform, we value advancement. I want to share you the big English words, the resolution adopted by the third plenum of the Communist Party in July this year. The one English word is a panorama. I hope that you can go to internet to find this text. You will see the panorama for China from now on until 2049, the 100th anniversary of founding of New China. That means the telescope photo for you to see the development China from now on. And also the 2029, we will accomplish more than 300 programs, policies, and projects by the year 2029, 80 years anniversary of founding of China. And also another milestone is 2015. 2015, the Chinese Communist Party will lead Chinese people to basically realize or materialize the Chinese modernization. And by the year 2049, we will build China strong, prosperous, democratic, and freedom, and culturally advanced and beautiful China. So I think this English word also gives you not only the thinking, the thought. It's very important about Chinese development, can provide a lot of opportunity for every nation. The third English word is about promise. The promise made by Communist Party should be delivered tangible result to the Chinese people. So we believe the Communist Party, the central government, have to make a promise, the prospect of China, to deliver, to make a policy, and also have a good program. The third English word is very, very important for you, for the perspective of China's, I use words, guiding thought, or guiding philosophy, or guiding, we use words, the path. And most important things, I think, the guiding principle. So you will see we have the guiding philosophy, guiding idea, guiding thought, and also the principle and the pathway. So I hope that this year's the resolution by the third plenum of Central Committee really means a lot, not only for mainland China to Hong Kong. Hong Kong will play the three existing international roles. One is the financial center, second is the shipping center, and third is trade center. And also we are supporting the new policy, new program for Hong Kong to be an international hub of talents. That means we have a special policy to attract the international talents to study, to work, to live in Hong Kong. And recently, Hong Kong's chief executive, Mr. John Lee, released his third policy address, committing to reforms that benefit the people of Hong Kong as a world-class springboard. So we today use the word springboard for connecting China with the rest of the world. Hong Kong has many unique advantages to leverage. I also want to take this opportunity to thank you, especially from the foreign countries, and also to our Consul General, Honorable Consul General, for your contribution to share the truth to the international community, because we know there are disinformation, misinformation, rumors made by, we can say, the insane people. Maybe I hate to use these words, but you are here seeing is believing. Hong Kong really is a good city. It's really a good city for business. It's really a good city for living in Hong Kong. So I hope that we should, and share the story of Hong Kong to the international community. And we do believe Hong Kong can do good things for the progress of every nation, especially for the international community. The first, I think, how can we leverage the policy advantage of one country, two system? So if you look at the globe big picture, only Hong Kong enjoy one country, two system. What's the meaning of one country? What's the meaning of two systems, I think that is a very good topic to discuss. I only offer two English words. One is free, and the second is independence, and the third is about sovereignty, and the last word is autonomy. So I think that if you understand the four English words, you really understand what's the meaning of one country, two system. The central government's unwavering commitment to one country, two system is the strongest foundation for Hong Kong's development. Why? Hong Kong enjoy two systems because Hong Kong can get things from mainland and also can link to the international community. Hong Kong can continue to enhance its unique role of super connector to facilitate trade and investment between Chinese and foreign enterprises. As the only jurisdiction in China that applies a common law system, Hong Kong can also unite diverse market participants and expand international connections. People believe common law is in favor of a business environment. The second, talent advantage. As the Asian Pacific Center for Legal and Dispute Resolution Service, Hong Kong can leverage its financial and legal expertise to provide support for business in investment planning, risk mitigation, dispute resolution. It can also use its talents strengths to align its regulatory policies and the governance standards with the international ones to further improve its business environment. I want to highlight the business people from all over the world. They are supporting the Hong Kong's rule of law, the Hong Kong's economic development. They also believe Hong Kong is a secure city for business. They also believe that the common law are good for them to do business. So I had the opportunity to talk to every chamber of commerce in Hong Kong. I want to share with you, really, they are investing a lot, especially for the big company. They are starting to invest in Hong Kong. They believe the good return of the investment, not only for the profit, and also can make benefit to the Hong Kongers in not only Hong Kong and in the international community. The third, location advantage. So in China, we always, like you, the location, and the location. For business, location is of a paramount importance. As a city where east meet west, sometime I'm thinking south also means north. No, that means the four direction. Hong Kong can act as a bridge for multicultural interactions, facilitate the legal assistance, cooperation, and the exchange of legal experience, and build sharing platform for legal service. Ladies and gentlemen, since its return to the motherland, Hong Kong has played a leading role in national reform and opening up. Since year 1978, we launched reform and opening up that we changed the course of Chinese trajectory development. So significantly, Hong Kong contributing to the country's stable and rapid economic development. I hope that bear in mind the very important figure, 60% of FDI is through Hong Kong to mainland. Even today, I think that Hong Kong business people, Hong Kong SAR government, will integrate with development mainland and also will play a very important role to feed FDI. So I do believe that in the coming years, not only 60% of feed FDI, foreign direct investment from Hong Kong. So this figure demonstrates the Hong Kong's unique strengths and the super connector between mainland and international community. Now, China deepening reform presents Hong Kong with a chance to explore new prospects. We look forward to Hong Kong embracing changes, leveraging its advantage, and creating a better future for all. To conclude, I wish this summit great success. I hope everybody to take your home value more from this summit. I thank you all for your patience. Thank you very much.
Thank you very much, Mr. Trude, for your kind remarks to kickstart today's events. Please be seated on stage. Thank you very much. Thank you very much, Mr. Trude. And now, ladies and gentlemen, without any further ado, I would like to invite Mr. Paul Lam Teng Kwok, SBS SCJP, Secretary for Justice of the Hong Kong SAR, to come up on stage to deliver his welcoming remark. Ladies and gentlemen, a big round of applause for Mr. Lam.
Commissioner Choi, Professor Tirado, Counsel Generals, distinguished guests, ladies and gentlemen, a very good morning. For those joining us from different time zones, perhaps I should say good afternoon and also good evening. I'm truly delighted to welcome you to the opening of the Hong Kong Legal Week 2024 and to the Asia Pacific International Private Law Summit 2024. The Hong Kong Legal Week is an annual flagship event of the Department of Justice, and since its inception in 2019, the Hong Kong Legal Week has served as a dynamic forum where legal professionals, scholars, judges, and experts come together to discuss critical legal issues that resonate not only within Hong Kong, but throughout the wider Asia-Pacific region and beyond. Now, the theme of this year is Hong Kong Common Law System, World-Class Springboard to China and Beyond. It emphasizes Hong Kong's unique role as a gateway between China, the Asia-Pacific, and the world. Under the one country, two system principle, Hong Kong is the only common law jurisdiction within China. Our strong legal foundation, coupled with our close ties with and support from the mainland, position us as a critical hub for legal and economic collaboration across the region and beyond. We begin this week's with today's Asia-Pacific International Private Law Summit 2024. Building on the success of the inaugural summit in 2022, the Department of Justice once again partnered with the International Institute for Unification of Private Law in INITRA to organize this summit under the theme Springboard to Opportunities, utilizing international private law and technology to facilitate access to credit, investment, and sustainable development in the Asia-Pacific region. The Asia-Pacific region is home to enormous economic potential and encompasses a diverse array of legal systems. While this diversity reaches our legal and cultural landscape, it also introduces complexities and uncertainties for business navigating cross-border transactions. To unlock the region's full economic potential and ensure long-term sustainable growth, harmonization and modernization of private law across the region is essential. Now, recognizing this need, today's summit gathered leading legal minds from across the Asia-Pacific, together from experts from UNIDRA, to explore how the unification and coordination of various areas of private law can support economic growth and facilitate smoother cross-border interactions throughout the region. We'll be hearing from them on how international private law and emerging technologies can unlock new opportunities for sustainable economic growth across the region and how Hong Kong may contribute in this regard. In the past few years, the Department of Justice has closely collaborated with UNIDRA to promote the development, implementation, and deeper understanding of private international law, international commercial law across the Asia-Pacific region. In addition to these collaborative efforts, we are grateful for UNIDRA's strong support of the Department of Justice Secondment Program, offering Hong Kong's legal professionals from both the public and private sectors the valuable opportunity to work at the UNIDRA Secretariat in Rome. This experience not only deepens their expertise in international legal issues, but also bolsters Hong Kong's capacity in foreign-related legal matters. I'm very pleased to note that one of our former secondees will be moderating a panel later this morning, which testified to the success of the secondment program. The secondment program is one of the Department of Justice's many policy initiatives, providing professional development opportunities to our legal talents. To further strengthen Hong Kong's position as a leading international legal and dispute resolution service center in the Asia-Pacific region, the Department of Justice places great importance on nurturing legal talents with a global perspective and proficiency in foreign-related legal affairs. We are committed to establishing Hong Kong as a leading center for capacity building in international law. As outlined in our Chief Executive Policy Address 2023 and 2024, the Department of Justice is setting up the Hong Kong International Legal Talents Training Academy. The Academy will regularly organize practical training courses, seminars, international exchange programs, and more to promote exchanges among talent in regions along the Belt and Road. It will also provide training for talent in the practice of foreign-related legal affairs for the country and nurtures legal talent consistent with international law, common law, civil law, and our country's legal system. A dedicated office and an expert committee have already been set up to facilitate the establishment of the Academy. We are grateful to have Professor Tirado as a member of the expert committee, and I'm pleased to see many of our committee members participating in today's summit. To officially mark this new initiative, I'm excited to announce that the launch ceremony for the Academy will take place on the final day of the Hong Kong Legal Week, and I warmly invite all of you to join us for this significant occasion. I also warmly welcome you to participate in an array of other events this week. Tomorrow, we will have the second Neo Forum on Interconnectivity and Development co-organized with the Office of the Commissioner of the Ministry of Foreign Affairs of the People's Republic of China in Hong Kong SAR. At the Legal Forum, we will be very pleased to have the General Counsel of Asia Infrastructure Investment Bank delivering keynote address on promoting good governance and high-quality development under international law. Legal experts will also share their insights on Hong Kong's role in China's institutional open-up and the rule of law as a risk management mechanism to safeguard sustainable development. On Wednesday, we will host an event under the theme Beyond Litigation, the vibrant landscape of alternative dispute resolution in Hong Kong. Today, we explore three topical issues: the role of mediation in promoting a culture of mutual respect, harmony, and inclusiveness; use of artificial intelligence in alternative dispute resolution, as well as the resolution of spot disputes. There will also be the 2024 Hong Kong Mediation Lecture in the evening, exploring the unique challenges and opportunities involved in the use of mediation in deals relating to natural resources. Thursday's program will focus on strengthening the rule of law in the Greater Bay Area. You will hear from experts on the proof of Hong Kong law and foreign law in the mainland, the arrangement of mutual legal assistance in civil and commercial matters between the mainland and Hong Kong, as well as legal services and juridical relations to facilitate and protect trade and social interactions between the mainland and Hong Kong. The day will also feature a mock mediation session led by mediators from mainland China, Hong Kong, and Macau, and a discussion on the Greater Bay Area mediation platform. On Friday, apart from the launching ceremony of the Academy in the afternoon that I just mentioned, where we explore how the rule of law in Hong Kong, together with different components of Hong Kong's legal and judicial system, are essential to provide the best business environment from the perspective of our legal service profession and our enterprises, and how our legal professionals can play an important role along the Belt and Road. Alongside this week's discussion, we are also featuring a special exhibition on the achievement in the construction of the rule of law of the People's Republic of China in the modern era, co-organized by the Ministry of Justice of China and the Department of Justice in celebration of the 75th anniversary of the founding of the People's Republic of China. The exhibition highlights key milestones in China's legal evolution, both domestically and in foreign-related areas, over the past 75 years. You are most welcome to visit the exhibition during the breaks or after the summit. It's just in the exhibition hall adjacent to this conference room. Ladies and gentlemen, as we look ahead to discussions that will follow, I hope today's summit will inspire all of us to explore new ideas and opportunities. Let's make the most of this moment to engage in meaningful exchanges and drive forward the future of international law. And on this note, I wish today's summit every success and extend my sincere appreciation to all of you for joining us, whether online or in person. And a special thanks to UNIDROIT for their unwavering support and heartfelt gratitude to all my colleagues from the Department of Justice and our dedicated partners whose hard work had made Hong Kong Legal Week 2024 a reality. Thank you very much.
Thank you very much, Mr. Lam, for your kind remark. Please be seated. And now, ladies and gentlemen, without any further ado, I would like to invite Professor Ignacio Tirado, Secretary General of the International Institute for the Unification of Private Law, UNIDRA, to come up on stage to deliver his welcoming remark. Should we all give a big round of applause for Professor?
Thank you. Honorable Commissioner Koi and Honorable Secretary Lam, First Deputy Chief, is the difficult title, First Deputy Chief Cabinet Secretary of the Government of Mongolia and old friend, distinguished and honorable consuls generals, Professor Zhao, representative of the Hague Conference on Private International Law, our sister organization and close partner in our activities, old-time friend, General Counsel of the Asian Infrastructure Investment Bank, distinguished ladies and gentlemen, friends, all of you. It is an enormous honor for UNIDRA to be back in Hong Kong for one of the legal world's, for what has become one of the legal world's leading events in the international arena. 2 years have passed. It seems impossible since we were here in the same setting in the beginning of the aftermath of the horrible COVID experience. And it gives us enormous pleasure to see that Hong Kong has flourished back into its old dynamic, efficient, cosmopolitan, multicultural self, an extraordinary and unique legal and financial hub that the entire world recognizes. It's great to see it back on its feet, stronger than ever. Allow me to take a second to make a special heartfelt reference to Deputy Secretary Choing and to the law officer James Ding, and especially to the entire team of the Department of Justice of Hong Kong Special Administrative Region. Through the experience in organizing joint events 2 years ago, but also in other occasions, as well as the secondment program, the very successful secondment program mentioned by Secretary Lam, we have forged friendships that go beyond professional relationships, and we are particularly grateful for this opportunity and grateful towards them for all the help that they have given us in these years and that we are hopeful will continue to give us. So thank you to the department, and we look forward to our future collaboration. UNIDRA has, in these 2 years, continued to grow substantially. We have 2 more member states, Mongolia and Singapore, who are being active, and we congratulate ourselves very much for that. Also, as an expression of what is a reality. While UNIDRA was created almost 100 years ago as mostly a European organization, it has grown into a truly global endeavor nowadays. And we can easily say that Asia has become one of its main focal points, if not its main focal point. It is indeed the region of the world we have visited the most in the past 2 years since we were here, with a constituency that now goes over 74% of the world population and more than 90% of the world GDP that represent our member states. We focus on the APEC region and Africa and Asia generally with enormous interest. Another good example of this is the newly founded Asian Transnational Law Center, which will allow us to bring to Rome professionals from governments, academics, researchers from the Asian region to work with us to promote our instruments, to deepen the Asian side of the instruments that we produce with a global perspective. So Asia is very much not only in our hearts, but also in our minds. And of course, Hong Kong and the People's Republic of China is a very, very important part of that. Our portfolio has continued to stabilize in areas where we thought we would be key for the growth of the world, and with a special and particular look to the global south. Our instruments on access to credit have grown substantially. We have taken close looks from the smaller organizations and looking at small and medium enterprises, which conform more than 90% of the world economy anyway, in the vast majority of countries, with a special look at agricultural economies, with our model laws on factoring, which cover the entire supply chain financing scenario, with our model law together with Ancestral on warehouse receipts, for warehouse receipts financing, again, very much linked with agricultural development, to the larger assets, with the continued success and enhancement of one of the world's most successful commercial law treaties in the world, the Cape Town Convention on International Interest for Mobile Equipment. We are very happy to report that apart from the increasing success of the aircraft protocol, we now have the rail protocol in force, which is an extraordinary piece of news for a global economy, because it's the missing key, the missing link to allowing countries to develop their railroad systems so that they can enhance sustainable development, because traveling and moving merchandise by rail is the most sustainable way of doing it. And that's an important part where we are hopeful that a difference will be made both in Asia, but also in other continents such as Africa. We have been working on an extraordinarily important project on financial stability together with the Bank of International Settlements from Basel. First time the Basel institution took an instrument outside of Basel itself, which is recognition of trust in our organization, with our work on bank insolvency, by almost 40 central banks, international financial institutions, and deposit insurers working hand in hand to provide best practices for the financial distress of small banks. And for that, we counted on Hong Kong's monetary authorities' help, also with the Central Bank of the People's Republic of China, amongst other central banks around the world. But the main focus of our work these 2 years and moving forward has two names or two concepts. One of them is sustainability and the other one is technology. And they are directly linked with the topics of this conference today. We have been working on voluntary carbon credits. We have been working on investment contracts between foreign investors and national agencies and governments, and how to introduce in those investments sustainable clauses, or clauses which reflect sustainable development. We've been working on corporate sustainability due diligence, and some of our Cape Town Convention protocols, like the MAC protocol, are key in sustainability as well. And concerning IT, we'll be talking immediately now about our already successful digital assets and private law instrument. We've been working on e-platforms for the assignment of receivables, and we generally are working with technology and how it applies to our instruments. So we will have the opportunity to talk about all of this in the coming days, so I will not bore you anymore, just a little bit. Allow me to finish with a brief thought. We were founded in 1926 in the context of the League of Nations, the predecessor of the United Nations, which had in its mind and in its soul sustainable development already. Because when the League of Nations was founded, They founded a satellite organizations, the World Health Organization, the International Court of Justice, the World Labor Organization, and UNIDROIT. So they had not only growth in mind, they had sustainable growth in mind. And we have and we will continue to honor this approach to transnational lawmaking. And in 2 years, we will be celebrating our centenary. We count strongly on the support, the collaboration, and the help of both Hong Kong's Special Administrative Region and the People's Republic of China, and generally the Asian region, as a key part not only of our celebrations for the centenary, but also for the 100 years that will follow the centenary. Thank you very much.
Thank you very much, Professor Dorado. Please kindly be seated. Thank you. So now, ladies and gentlemen, we're going to proceed to our first panel discussions, and the topic is harnessing opportunities from digital assets, tokenizations, and carbon credits. And I would like to invite the moderator and panelists of this session to come up on stage. So our moderator for this session is Mr. Kevin Lau, former legal officer of UNITRA and barrister at law at the Vote Chambers. And the panelists are Professor Ignacio Tirado, Secretary General of UNITRA, Professor Kelvin Low, member of the UNITRA working groups on the legal nature of verified carbon credits, and Professor of Private Law at the University of Hong Kong, and also Mr. Ernest Ho, Head of Digital Finance at the Hong Kong Monetary Authority. Should we all give a big round of applause and welcome our moderator and panelists? So we will be having 4 panel discussions today, and after each panel discussion, there will be a Q&A sessions. So if you have any question, please scan the QR code on the screen, on your table, or around this hall, and submit your question through our online form. And for our online participants, the QR code should be shown on the screen. Our moderator and speakers will try to address the question at the end of each session. And now, without any further ado, I'm going to pass over the stage to Mr. Lau.
Commissioner Cui, Secretary Lam, Consuls General, distinguished guests, ladies and gentlemen, a very good morning to you all. It gives me great pleasure to kick off Legal Week today by moderating the first panel. So we have on stage with me Professor Tirado, Professor Low, and our own Mr. Ho from Hong Kong. So I'm not going to go into a very detailed description of the bio or the background, because you can find all of that in the conference booklet. But what I will do is just very briefly introduce what they're going to be sharing with us today on stage. So the cat is out of the bag. I am the former secondee to UNIDROIT, and it gives me very great pleasure to see my old boss and also my friends from UNIDROIT here today as well. So Professor Tirado is going to be talking to us a little bit about UNIDROIT itself, of course, but also about 2 of the most recent flagship projects of UNIDROIT, one concerning digital assets in general, and one more specifically focused on voluntary or verified carbon credits, which is, of course, a subset of these digital assets. Now, Professor Tirado, of course, we very warmly welcome him and UNIDROIT to Hong Kong, and it's a great pleasure to have him here to share about UNIDROIT's very professional and very unique perspective in harmonizing international private law and in sharing their insights and experience gained from liaising with many different international experts on their various fields. So I think without further ado, I'm just going to pass the stage to Professor Tirado and hear him share about UNIDROIT and its recent projects. Thank you very much, Professor. I think so. Yeah, I think for your PowerPoint. Thank you.
To change from here. Okay, great. Thank you very much. So thank you, Kevin. It's a pleasure to see you again. It is an honor to be sharing a panel with a friend, Professor Low, and with Mr. Ho of the Hong Kong Monetary Authority, who are the real experts. I'm here just saying what our experts say. So indulge me for that. And apologies for taking the floor again. You've already heard enough of me. I'm trying to, am I supposed to press the green button? Oh, it's already there. Okay, sorry. Now back, it's the red one. Okay, right. Okay, so I'm going to talk about two. If you can see, in the title makes reference to two types of possible types of new forms of property. It's unclear whether they are new forms of property or not. They are new types of reality, and whether they require or not special treatment is what these projects in a way are about, and hence the name of the discussion. The first of the two, excuse me please, the first of the two concerns the digital assets and private law project. It's a project which started quite some time ago and is finalized. We have already the instrument. It was started at the request of the governments of Hungary and the Czech Republic, and the proposal was a more general one, and we divided up the work with our colleagues from the United Nations Commission on International Trade Law. We did the part on digital assets, and they did other parts of the technological reality. The work that we did together with an extraordinary group of globally representative experts and a number of hugely relevant stakeholders in their capacity as observers, and I'm thinking about the Uniform Law Commission, the Law Commission of England and Wales, the European Central Bank, the American Law Institute, or to signify, for example, the private sector, the Association of Global Custodians, just to mention a few of those. Right. So when we started this project, what we did is ask ourselves, are digital assets a new type of thing? And how much new law is needed to tackle this new reality in case there is a need for any adaptation? And although our approach was to produce an instrument which was enduring and useful for as long as possible, and for as wide a constituency as possible, we sought to follow two tenets. One, that of technology neutrality, and that of jurisdictional neutrality, meaning the result should be useful for both civil law and common law jurisdictions. Of course, this is part of what we always do. But we needed to look at it with modest eyes, because we, first of all, wanted to ascertain whether there was a need for this new instrument, but then what would be the shape and the outreach of this and the scope of this instrument. Because digital assets, and mostly focused on what we could label as distributed ledger technology, are indeed an intangible thing, but they do share, this is quite evident, its technology does share some trends or characteristics that, as a matter of fact, can be characterized as relatively analogous to a control that a person can have on a tangible asset. So it is intangible, but it has a tangible soul. And in fact, there are some countries, very important countries, that have expressly determined that digital assets are to be treated as tangible property for the purposes of their own law. So in light of this reality, what we thought is, within our mandate, which only covers private law, and I will get back to this, what type of instrument should we prepare? One which is most useful, but is not intruding. And we agreed, everyone agreed in the working group, and then the governing council ultimately, that it was best not to create a fully fledged instrument that regulates all private law aspects of digital assets. That wouldn't make sense. It would be intrusive and enter into areas where there is no need for harmonization or clarification, but rather to focus on those specific points which are key and which might help fill some gaps and provide guidance to countries to regulate or use their own private law systems applicable to this type of reality. So it was a modest approach, not regulate everything, just fill the gaps and clarify concepts. That's the idea of this instrument, so that countries can modernize their legal system in these regards. This way allows for domestic updating of systems, while at the same time provides global harmonization at high level without a new system being implemented. So that was a bit the idea, and we thought that less was more in this case. How did we characterize digital assets? We characterize digital assets quite generally as an electronic record capable of being the subject of control. We understand that that definition is broad, very broad, and capable of encompassing very different types of animals in this sphere. But the reason for it was we are only looking at private law matters, and therefore we are only concerned with, let's say, the tradability and trading-related matters concerning this type of property. And therefore, we want to make sure we capture everything which is being traded out there. That was the idea behind it. Of course, soon it was relatively evident to the experts and to the group that although it might not have been a foregone conclusion, it looked a little bit like it, because everyone agreed that DAs could be subject to proprietary rights, although that was the beginning of the analysis. The concept, the main concept of digital assets, of the whole analysis, the transaction analysis of our digital assets principles was based on the concept of control as functional equivalent to possession. And control, which has its own principle, I won't go into detail, but is mostly a type of control which is factual and non-legal, and which would allow the person or persons having control to behave in a manner similar to someone having control of a tangible, as I said before. So a person in control can transfer digital asset to the person, to the control of another person. A person in control can prevent others from transferring the digital asset at the same time, and a person in control can obtain substantially all of the benefit of digital asset. So those were the three main characteristics of control, factual as we described it and conceived it. Right. Sorry. Okay. Right. So the way the analysis we provided observed a reality upon which a digital asset could be in control for a person. A is a node, A controls through a non-custodial wallet, but A continues to be the owner of the digital asset. We also saw the possibility of holding by B, so A transfers control to B, who holds it on A's behalf, which is what we call custody in the principles. So what is important for us is that A continues to have proprietary interest in the assets, and A is safe from the insolvency of the intermediary or the custodian. So either A holds his own asset, either A gives it to a custodian but keeps property and is safe from insolvency, or A transfers control and ownership of the digital asset to B, with all the consequences in terms of risk that brings about. Those were the three situations which we analyzed. And before I say a few more things about that, very briefly, I'd like to say that one of the main parts of our digital asset instrument is also the special rule which concerns the innocent acquisition rule and the shelter rules, which we thought were necessary in order to protect legal certainty in markets that were developing rapidly. We analyzed custody and produced a number of principles which are very important in that sense, but custody for us is only when the custodian enters into a custody agreement in a restrictive sense, so that, as I said before, we are in the B situation, in which, because of several ways in which the custodian or the intermediary is handling the digital asset, the insolvency risk is not passed, or the insolvency risk of the custodian or intermediary does not affect the ownership of its clients. We provide some guidance as to how to do this and how to implement the adequate duties of the custodian. Another element which is, we believe, especially important to highlight in this very brief presentation is what concerns security rights, because one of the main elements of digital assets and private law is precisely the possibility of using digital assets as collateral in financial transactions. Here, since we believe that digital assets can be the subject of proprietary rights, obviously it is also possible that it can be subject of security rights or security interests, as you want to call them. I think perhaps the two main rules in this regard are the following. The principles allows for the creation and perfection of security interest by way of control. But not only that, in case there is a security interest created by way of control and any other way, such as, for example, registry, control trumps registry. And this is an interesting thing and an important thing because it involves an important policy option, which should be considered. We have an important rule on conflicts of laws, which is based on party autonomy, which states a waterfall system of criterion to determine law applicable, not jurisdiction applicable law. And there are a number of reasons why we believe that party autonomy was the right choice. The party autonomy is envisaged in the rules, choice of law, as specified in the digital asset or in the platform. And in case those two don't happen, then the law of the issuer of the state under certain circumstances will be the one applicable. This is a very important principle, has been perhaps the most controversial one. I'd like to, from the start, underscore that we do not do the regulation, that we do private law. So our principles are agnostic as to the possibility of the authorities implementing regulatory protections for consumers or users of digital assets. We do not say anything about that. So a country, this Principle 5 doesn't run counter a country deciding to implement specific regulatory constraints to the transactions. So there is no contradiction, there is just no regulation in this regard. I think it's important to mention that. And very briefly, because someone is walking with a, someone has passed with a thing which says 1 minute and it went from 3 to 1. I think the 2 was left somewhere. So I'll just be very brief. The other part is the verified carbon credits. I'll be very brief because Professor Law is going to talk about this much better than I could. Just say that this project, which is underway now and is well advanced, was started at the request of the International Swaps and Derivatives Association. Is that they came to us and said, we are trading on voluntary carbon credits, the markets are growing, there is an interest in scaling these markets in order to further the objectives of the Paris Agreement, Article 6, but no one really knows what they are. So we keep buying and selling and creating derivatives over a collateral whose legal nature is uncertain. That creates uncertainty and prevents a full scaling of those markets from actually happening. So we need an independent, intergovernmental, technical organization that provides a thorough analysis of this reality says what it is, and solves those problems so that markets can have trust and full investment flow from not only nationally but also internationally. So that is how it started. What we are doing is we're working on the legal nature of VCCs so that issues such as registration, issuance, transfer, retirement of the credits, and their impacts on collateralization and insolvency are analyzed in detail. I should say it's a fascinating project because we see, even in the way that the main players of the system operates, the registries, standard setters, verifiers, everything is still relatively unripe, or perhaps to be more use a kinder expression, it's in development. It's a market that's in growth, and therefore things are still developing, and we believe we can substantially contribute. The instrument will be a soft law instrument similar to the principles with commentary, which we believe will be very useful, and we, of course, as usual, seek to enhance legal certainty and promote cross-border investment. This is the draft structure as it is now. It might change, it might grow, it will not be reduced, and we're hopeful that within a year we will have an instrument. So thank you very much for your kind attention and for your patience with me. Thank you.
Thank you, Professor Tirado. That was a very insightful introduction to UniDoir's work, and I'm sure that our attendees here in the conference will be very keen to catch up more on with you and to ask more details about UniDoir's two projects in this upcoming week. Next up, I'm very pleased to introduce Professor Kelvin Loh. Professor Loh is a professor of private law at Hong Kong U, my alma mater. So this morning when I told him that I missed him by one single year during my university studies, he told me, "Good for you, lucky you." So I think my transcript and my grades will have to thank him for that. So Professor Loh is a leading expert in the arena of the law of digital assets, the proprietary consequences and so on and so forth, insolvency consequences and so on and so forth. But more importantly, he's not just an academic. As Professor Tirado foreshadowed, Professor Loh is actually a member of the working group of the UniDoir's VCC project. So Professor Loh is actually currently working on the project on the voluntary carbon credits that Professor Tirado introduced to us just now. And that's what he'll be sharing with us today. So without any further ado, I'm going to invite Professor Loh to talk a little bit about what the project is and his experiences thereon. Professor Loh, please. Thank you.
Thanks, Kevin. So this is my first experience as an expert at UniDoir. So this is my first working group experience. So I can't say for sure whether this is similar to other working groups. I suspect not, right? Because I think if you look at most of the other instruments that UniDoir produces, they tend to revolve around things that are, fairly established property. The kind of transactions you can do with them are fairly clear. There may be discrepancies across legal systems, but every legal system sort of knows what you can do. How do you take security over a book debt, for example? This is a bit more like the digital assets project Ignacio was talking about earlier. Far more embryonic stage of development. Is it property? Is it not property? This is one of the big questions. The digital assets working group, they obviously concluded that digital assets were property. Now, when you deal with private law matters, I've been teaching now for more than 20 years, and I've taught almost every private law subject out there, with the exception of tort law. And I can say that property is the most difficult to teach for a number of reasons. Firstly, students come with preconceived notions, right? As lay people, we have ideas of what is or is not property. And I have to kind of beat that out of them. Different legal systems have very different conceptions of property. And even within a legal system, there is not necessarily clarity, right? So you can find, if you put 10 English lawyers in a room and ask them, is this property or is this not property, you'll find disagreement. So there are some English lawyers that take the view that intellectual property is not really property. Some may say that some intellectual property is property and others are not. Right? Is equitable property property? Some English lawyers think not. Right? And of course, once you cross legal systems, it becomes even more complicated. In civil law countries, in Germanic civil law countries, like China, then you have this division of property as things and property as wealth. Property as things would be 物权, and property as wealth would be 财产法. And you have different terms to describe different concepts, whereas at the common law, we very often mix up the two. So this is just by way of introduction of how complex the idea of property is. And unlike digital assets, right, VCCs, verified carbon credits, does not have the benefit of mimicking one of the natural characteristics of tangible things, which is rivalrousness, right? This is a word that most people probably haven't come across, but basically the idea is, you know, if I take this cup, then I have possession of the cup. And Ernest does not, Nacho does not, Kevin does not, none of you do, all right? And control over digital assets is said to be similar to that. But you don't have something like that naturally occurring for verified carbon credits. So the question, of course, was how would we fit this within any regime of property? So we've now had 3 working group meetings, each lasting 3 days, and we explored various possibilities. One very early possibility that we toyed with was, could we say that there was some sort of right, right? Because property as assets, in the wider sense of the word, included rights. So contractual rights, what Nacho referred to shows us in action, are property in common law systems. Why are they property? Because we allow them to be transferred. Transferable rights, even if they are only personal rights, are property in this looser sense of the word. So one of the things we started searching for was, can we find some sort of rights, right, to verified carbon credits? Problem, of course, is if you have a verified carbon credit, this doesn't give you a claim against anyone, right? Now, then, of course, we had to deal with the difficulty that you had a lot of different players in the space, and they all did their own things, right? So the biggest player in this market is Vera, and Vera, I believe, drafts their terms based on English law. They use the deed system in English law, specifically the deed poll, to effectively more or less create something similar to transferable rights, right? So because they use a deed poll, the claim can be exercised by anyone who has the right. But Vera is only one player. It may be the major player, but it's only one player. And if you look at some of the other systems, like gold standard, then there is no right. So we very quickly realized we couldn't go down this route, and therefore we adopted a different tack, and I believe the current strategy is to create rivalrousness, right, in the same way that you find rivalrousness in digital assets. And once you got over that, you also had to deal with the problem of trying to define what the property is. And this was something, again, we had a lot of difficulty with, because speaking as an academic, we have a number of academic experts in the working group, and you have a lot of experts who are not academics, they're actually players in the market. And there was a lot of difficulty trying to translate what we were all talking about with each other. So for example, to a lot of the market players, the property in carbon credits is the fact of reduction of 1 metric ton of carbon dioxide or its equivalent, or a claim that there has been a reduction of 1 metric ton of carbon dioxide. To an academic, however, that doesn't work, especially as a legal academic, it doesn't work, because no legal system that I know of allows anyone to own facts. Right? Information is not property. So if your starting point is, we're talking about information, this cannot work. It will not fly. We also had a lot of difficulty with the use of the word claim, right? Because in legal systems, when we are talking about claims, it's claims against persons, not a claim that I have achieved a particular set of facts, because again, that is just a claim to the truth, if you will. So we're still struggling over the language. The academic experts prefer representation, but despite trying to persuade the end users, I don't know how successful we are, because we're kind of midway through the drafting. Now, leaving aside the how do you fit verified carbon credits into a property regime, then you have to deal with the life cycle of a VCC, right? It gets issued, gets transferred, and at its end point, it gets retired. Now, I'm not going to talk about those because I'm not the one responsible for drafting. So I want to talk about the principles that I was responsible for drafting, at least in draft. They're not finalized. I'm going to have to majorly revise them. So I want to talk about revocation and reversal, right? So what happens if you find out 5 years down the road that the VCC that you bought, actually there was no reduction, right? Somebody in the chain had lied. What do you do about the VCC, right? So to an academic, familiar with other types of intangible property, the immediate thought is, okay, if you've applied for a patent, you were granted a patent, but subsequently the court rules that, one of the key elements of a patent was not there, right? Whether it's not novel, it's not, innovative, doesn't really matter, then the patent doesn't exist, right, from the beginning, right? It's void ab initio. This would be similar to revocation that we were thinking of. What would be closer to reversal would be something like, if you had a trademark, one of the requirements for sustaining a trademark is you keep using it, because if you stop your business, then, somebody can get your trademark removed. So again, the analogy in the VCC space would be, let's say you do a carbon sequestration project, you've captured the carbon dioxide, but for whatever reason, act of God, accident, the carbon gets released, right? Do we then have to reverse the VCC? And then, of course, the question is, who bears the risk? How do you deal with this? And one of the major problems, of course, was the market players don't want the risk, right? They all do not want the idea that VCCs can be revoked or reversed, or at least not without recourse. And this then brings me to one of the great difficulties we also face, because when we are drafting the principles, our primary mandate was to focus on the property aspects, because contracts, of course, are entirely up to the parties, right? We cannot dictate that issuers must include particular kinds of terms in their terms of service. So this creates the impression that there is no recourse, whereas in truth that's not quite the case. Really, it's up to the market players to demand that I will only buy VCCs if the issuers protect me when one of these things happen. And then, of course, it's up to the market to then negotiate, what the price of this protection is, right? Whether it is the issuer holding a buffer pool of VCCs that is not sold and then using this to replace any revoked or reversed VCC, whether it is direct pure financial compensation, whether there is any limit to how long these guarantees last for. This is something for the market to work out. This is something for the contracts between the parties to work out, right? So the principles can only, the way I put it is, state the worst case scenario, right? If nothing is said in your terms of service, what should happen, right? And that's how we have gone about drafting it. But as I said, this is very much work in progress. I immediately after today's meeting ends, I have to go and do my homework, or Nacho would be very upset with me. I'm going to have to redraft my principles. So I think I will end there because we're running a bit short, and hand over to Kevin again.
Thank you, Professor Low, for very detailed insights as to specific issues when one is trying to come up with draft principles governing this very novel class of assets. Next, we're going to introduce Mr. Ernest Ho. Now, Ernest is our Hong Kong representative on this panel, although, of course, Professor Low is also from Hong Kong U. But Ernest is head of digital finance at the Hong Kong Monetary Authority, and he's going to be sharing a little bit with us about general perspectives from a regulator's point of view about the development of the digital asset space in Hong Kong and how to approach it and how to regulate it. Now, I believe Ernest's sharing will dovetail very nicely with what Professor Tirado started off with, because everyone will recall that UNIDOIR's work carves out and does not deal with the issue of regulation or regulatory issues. And here we have Ernest here to help us fill the gap, to provide us with more insights about this particular missing piece of the puzzle. So I will now hand the stage over to Ernest for the presentation. Thank you very much.
Thank you, Kevin, for the kind introduction. I'm humbled today to be surrounded by a large group of legal experts in the room and also online, especially given the fact that I'm not a lawyer by training. Today, so I'm just going to go through 20 slides in 10 minutes. I'm going to go through things in the market, policy, and regulatory perspective. I'm going to focus on three things here. First is a super high-level overview of digital asset ecosystem. And the second part of the presentation is about, I'm going to deep dive a little bit on stablecoin. And in the very last part, I'm going to talk a little bit about the implication from a legal perspective. All right, so first thing first, I think a lot of people talk about the potential of distributed ledger and, for example, blockchain, the potential for it to transform financial systems and the sectors. But I guess the more important question is, why is it so special? I think one way to look at it is to compare the distributed ledger with the traditional ledger and see what's so special about it. In the traditional ledger, there's always a centralized entity that keeps all the records. Every transaction needs to go through this centralized entity. But on the contrary, in the distributed ledger system, there are multiple copies of the full records in different parts of the ledger. And transaction doesn't have to go through any centralized entity at all. They could do so in a P2P manner, so to speak. So I think this is really a key difference. If I have to identify the differences in just 1 minute, this is the key difference that I see of distributed ledger compared to the traditional ledger. So I guess the next question is, with the ecosystem sort of shaping up, what's next? I think when people started to adopt digital asset technologies and also engage in digital asset activities, people started to not just thinking about transferring things from my wallet to your wallet. People are starting to think about, for example, more sophisticated services, products, and this is when intermediaries, which is essentially centralized entities, again, emerging in the markets. For example, here I just listed out a couple examples there. For example, there are virtual asset trading platforms, essentially centralized exchanges, which provides a venue, a platform for people to exchange tokens. There are also broker-dealers that facilitate trading or distribution of tokens. There are also custodies, which help safeguard users' assets on the blockchain. And so, again, with all these centralized entities emerging or intermediaries emerging in the ecosystem, the next key question is, what are the opportunities for digital asset? Why do we need that in the ecosystem? I think there are many different ways, multiple use cases that we see in the ecosystem, but I think from our perspective, the way we look at it is we want to understand whether digital asset could be used to solve real-world pain points in the real economy. For example, could it make transaction more efficient? And one of the use cases that many people quote would be on the payment side in conditional payment, for example, because of the fact that things are being run as just like a piece of software on a common platform. So there's a possibility to make payments a lot more efficient. For example, even in a conditional manner, people call it programmable payment, for example. And there are also other use cases that are long-standing pain points in the traditional financials world. For example, trade finance. This could potentially be sort of solved with the use of digital asset as well. But then when there are new opportunities out there, they always come with emerging risk. This is exactly why there has been a lot of discussion among international global regulators and policymakers in international forums around how to regulate digital assets activities around the world. And at this point, there are broad consensus among international bodies and global regulators that digital asset activities would need to be regulated properly across different jurisdictions. Here, I just list out two examples of international bodies, for example, the Financial Stability Board and also the Financial Action Task Force. Again, I think the consensus is very simple. Digital asset activities will need to be regulated properly in all jurisdictions. Here is just really just a very high-level summary of some selected jurisdictions and how they actually regulate digital asset activities. Here, I'm not going to bore you with all the details, but I think two things I would like to highlight here. First of all, in terms of intermediaries, we can broadly distinguish them into two categories: token issuers, and then the other, VASP, which is virtual asset service providers. Token issuers, the focus is particularly on stablecoin issuers, and they're usually regulated by the central banks of the jurisdictions. And there are the other virtual asset service providers there. For example, as I listed out here, trading platforms, broker-dealers, and custodies, they're usually being regulated according to securities regulations. So next up, what about Hong Kong? In Hong Kong, I think our sort of philosophy and principles are quite similar to what I just discussed. It's quite consistent with international practices. And here, I think the focus is on these three activities that I listed up here: the virtual asset trading platform, stablecoin issuance, and OTC. But I guess we get a lot of question on why we focus on these three activities. I think the answer is because we're not trying to regulate things as they emerge in the ecosystem. We regulate because there are risks, coming out of it. And as we think about digital asset, I think the major risk there, from our perspective, is first and foremost the interconnectedness or potential interconnectedness of the digital asset ecosystem with the traditional financial ecosystem. And so here, what we're trying to regulate here is where the two systems interact with each other. Meaning when people try to, for example, convert fiat into digital asset or vice versa. And there are different ways for them to do it. For example, they can do it on a virtual asset trading platforms. They can do it through the stablecoin issuers. They can also do it in OTC shops, for example. This is why we focus our regulatory efforts on these three types of activities. So next up, I want to focus a little bit on stablecoin. Again, one of the key mandates for our team this year and next is to implement a stablecoin issuance regime in Hong Kong. And just very, very, very briefly, what is a stablecoin? A stablecoin is, as the name suggests, is stable against something. And from a regulatory standpoint, a focus is on fiat reference stablecoin, meaning that stablecoin is linked to a fiat currency. You can think of it very simply as, on the one hand, the users would provide the issuers with fiat currencies. On the right hand, the issuer would issue tokens with corresponding value to the fiat currencies in a token format on the blockchain. And again, our focus on regulating stablecoin is not just about regulating the space, but we also want to make sure stablecoin is being used in a way that could solve real world economic pain points out there. And through our own efforts and also market engagement and also our sandbox, which I can discuss later on, we think that there is potential for stablecoin to be used to solve real world pain points. There are a couple ways, a couple different pain points that we see in the market that stablecoin issuers try to solve. But mostly, I mean, from a sort of holistic standpoint, we see a couple use cases that are most cited by participants out there. For example, payments, especially cross-border payments, and also supply chain management, and also in the capital markets perspective, there are many use cases in terms of facilitating transactions for tokenized asset and also collateral management. And in terms of the existing landscape for stablecoin right now, as you can see from the table, this is sort of just a league table of the top 10 stablecoin issuers by market cap right now globally. I would focus on the last two columns of this table. I could highlight two things here. First of all, the top 10 stablecoins out there in the market are all fiat reference, and here in particular US dollar reference. And the second thing I'd like to highlight here is the stabilization mechanism. Most of them, especially the larger ones, are fiat backed. And that's exactly why our regime focused mainly on fiat reference stablecoin, and we require them to stabilize it with fiat as well. And here, I think I just talked about generally about why we need to regulate. It's because there are risks involved when new things come up and merge in the ecosystem. I think, but overall speaking, we talked about the risk of interconnectedness, financial stability, and monetary stability. But most of all, I think it's also very important to highlight that our regime is meant to protect the users in Hong Kong. And here, I think the focus here to include this slide is to really just reiterate what I just mentioned. The focus of the regime is to regulate issuance activity in terms of fiat reference stablecoins. And there are three types of entities that we would like to regulate here in Hong Kong. Number one is obviously issuers that issue fiat reference stablecoins in Hong Kong. And secondly, any issuers anywhere in the world that issue Hong Kong dollar reference stablecoins. And thirdly, also entities that actively market the issuance of fiat reference stablecoin in Hong Kong or to the public of Hong Kong. And I just mentioned about also the importance of user protection. Here, our proposed regime has specifically included different kinds of provisions to protect users of Hong Kong. For example, we would only allow specified licensed entities to offer fiat reference stablecoins, number one. And number two, we would only allow licensed fiat reference stablecoins to be offered to retail investors in Hong Kong. The other unlicensed fiat reference stablecoins could be offered to professional investors, since we believe that they know what they're doing, they are more sophisticated, and they understand their own risk appetite. And also, we also understand that there are a lot of instances where there's, for example, scamming the market. So we have include explicit provisions to prohibit advertising of unlicensed fiat reference stablecoin issuance and also unlicensed offering of fiat reference stablecoin as well. I'm just going to go through really quickly because I think I'm really short on time. I think from a regulatory standpoint, there's no magic here. We obviously have a stablecoin issuer-specific type of requirements, but also other potential requirements such as financial resources requirements, physical presence in Hong Kong, and so on. And lastly, I just want to also highlight, because of the fact that we're dealing with something so new here, we are now running and managing a stablecoin issuer sandbox. This sandbox is meant to be sort of a formal channel to communicate with potential issuers and market participants out there in terms of what they see in the market, what are the potential use cases, and also to communicate with them, more importantly, our supervisor expectations further down the road. And lastly, very quickly, I think from a legal perspective, we do see a lot of developments out there. For example, I think there's a recent Hong Kong court case that confirms that cryptocurrencies is a property, can be privately owned, and can be treated quite similarly with other assets. And market participants in industry bodies like ISTA, they have also come up with contractual frameworks for issues as well. For example, there's always discussion on settlement finality, and also what if a blockchain is being forked, how do we deal with that? And also there's going to be issue relating to integration with the traditional financial system. But all of this I feel like is emerging and also in the development, evolving as well, and I don't see it as a deal breaker. We do believe that this could, digital asset could potentially be useful to the ecosystem and be adding value to the economy. So I think I am a little bit overrun a little bit, but this is all I've prepared today. Thank you.
Thank you, Mr. Ho, for that sharing about a very practical overview of what's happening in Hong Kong. Now, ladies and gentlemen, we're going to move on very quickly to the Q&A session. As previously mentioned by the Master of Ceremonies, there is a system in place for you to scan a QR code and to forward your questions to the organizers, so that I can see that on my iPad here, very high-tech manner. But to get the ball rolling, I'm going to exercise my moderator's prerogative and ask a short question of my own. So I think a common theme from all three presentations is that the digital assets revolution, particularly as it touches the law, is here, and it's here to stay. So I think my question for all three panelists would be, basically, what can we as stakeholders in the legal industry, so lawyers, maybe law students, law schools, industry participants do, in your view, to better prepare yourself or to engage with these ongoing changes in the law as it pertains to digital assets? Perhaps if I could pick, I will pick perhaps Professor Low first, seeing that you're actively engaged in the university at the moment, so perhaps you can help us from the law school and law students' perspective.
Okay, so I don't know that there's anything we need to do in terms of legal education. A lot of the problems really is that it's one thing to say that digital assets are property. That doesn't actually answer a lot of questions. So what follows when you say something is property? What rights does the owner of the digital assets have? What sort of recourse does the owner of a digital asset have when, let's say, he is hacked? And unfortunately, if you look at the numbers, it's not looking very good. The system is, of course, designed to be immutable, censorship resistant, pseudonymous, which creates a lot of problems when it comes to recovery, right? You see many more cases in common law systems where people try to recover crypto assets because the common law tends to be a bit loose and fast with claims. So we allow actions to be brought against defendants whose identities are unknown. So most crypto claim cases are X versus persons unknown, all right? You can really only bring a claim when you trace your crypto assets to a third party, usually an exchange, and you suspect that the exchange is amenable to the jurisdiction of the court. And then again, another factor for the common law comes into play. The common laws are very generous with interim remedies, so worldwide Mareva injunction, freezing orders. You can get all that. When I speak to my civilian counterparts, so I work with somebody in Japan, she says no one has brought an action, right? Because the civil law system is a lot stricter. You must identify the defendant. You don't get generous interim remedies. Now, in the early years, you had some limited success. But again, if you look at the facts, these are usually claims brought by people who have lost a lot of crypto assets. We're talking in the millions, because again, you have to spend money to get this back, right? You have to first hire a crypto analytics firm to trace your crypto, hope it gets somewhere that you can find. Then you've got to pay lawyers, right, who only take fiat, I'm sorry, to try and recover this. And in the early years, again, fairly successful, but now the exchanges are fighting back, right? So Binance, I think last year, objected to being named as a defendant and then got cost orders in its favor. More recently, just last month, I believe, in the English High Court, the expert for the plaintiff was put on the stand and could not explain how he did the tracing exercise, and therefore the plaintiff failed, even though the judge said the exchange was doing things in a really shoddy manner, unacceptable. But you couldn't prove that that was yours. So I don't know that there's very much we can do until the courts clarify what rights there are, and or there is greater adoption, because right now I think adoption is still rounding error compared to traditional financial markets.
Thank you, Professor Low. So perhaps I can just very quickly ask Professor Tirado about this. In terms of awareness building, because as Professor Low mentioned, just being uptake and being more aware of these things might be one of the ways forward. So particularly here, from personal experience, working as a lawyer in Hong Kong, we don't really come across very often assets like verified carbon credits. So for example, just to use one example we've been discussing today. So is there anything we as lawyers or practitioners can do to perhaps help stay abreast of the developments here and to help, so to speak, drive the revolution, do you think?
Right. If I may just take a little 30 seconds on the previous question, just to say that, of course, our natural objective is to, or target the stakeholder is a legislator or a judge in a common law system, but there's also legislation there which might be helpful. There is a very important part which is purely regulatory and which concerns, has been very well described. It seems like a complete system here already, but which also includes technological literacy. You have to be careful because digital assets trading is accessible to maybe people who are not prepared to understand what they're trading with. So that's a part which is, of course, outside our realm. This is more for the regulator to deal with and to tackle. But we need clear rules, and the principles provide some areas where clear rules are mostly required. What happens in insolvency of the intermediary, what happens, because, as you know, holders of digital assets are pseudo-anonymous, if you want to call them that. You have to have them produce the assets, recognize the existence, identify them so that creditors can benefit from them. So there are a number of questions that require legislation, probably, and in order to have a complete system, there is at least one stakeholder, if we can call them a stakeholder, which is the legislator, or the judge with capacity to determine the legal system in a different type of legal system to act. Sorry, because I thought the previous question was a very... Shall I take a stab at the other one, or just... Can you repeat it? Because
no, I'm just, the question was just for practitioners and lawyers in general. Is there anything we can do to stay abreast of development? So that seems to be something that, Professor, you've kind of talked about already as well.
Well, in our case, all our instruments are online, available. You can look at the work that we do. Everything is up there, and I think it's supposed to be told in a way which is understandable to a large community. So I would encourage to visit the UNISRAT webpage because I think it's quite instructive.
Thank you, Professor. Now, I think just to, again, invite Mr. Ho to perhaps dovetail with Professor Tirado's comments about the role of the regulator or the legislator, so perhaps more from that perspective.
Yeah, well, thank you. And I just want to say, supplement that I agree totally with Professor Tirado's point about protecting users and also making sure they know what they're doing as they were doing digital asset transactions. And I think this is exactly why regulation is important, because we're not just trying to regulate the space, but we're also sort of trying to establish best practices in terms of how to run these businesses. And I think Professor Low talked about, the problem with, tracing and all that. I think these are interesting case point that I think we should focus on. And also, I think in the end, when something bad happens, how do we make sure, we could require, for example, intermediaries to produce enough evidence to help law enforcement agencies to recover assets, for example. And I think this is the kind of thing that we're trying to get to with our regulatory regime, not just for frequent issuers, but also for, let's say, the exchanges, the custody, and also broker-dealers. So I just want to echo that, and then we are working towards that.
Thank you, everyone. So I think we've reached the end of our panel session. Now, I'm sure everyone will have many further questions for our speakers, and I will invite you to approach them individually after this session. With that, I'll just call an end to today's panel 1. Can I have a big round of applause for all of our speakers, please? Thank you.
All right, thank you very much, gentlemen. So please remain seated. Please remain seated and look at our official photographer in the center for a group photos. Please remain seated. All right, please look at our official photographer in the center. And please continue to stay for our media friends as well. All right, a big round of applause for our moderator and panelists. Thank you very much. So please kindly exit the stage and be seated off stage. Thank you very much. So ladies and gentlemen, we're going to take a short break right now. So the next session will start at 11:05. For those who are here in person, please feel free to enjoy some light refreshment that we have prepared for you outside the hall. And for online participants, please stay connected and enjoy your break. And I'll see you at 11:05. Hello, ladies and gentlemen. The second panel discussions will begin shortly, so please kindly be seated. And just a gentle reminder for all of our audience, please turn your mobile phone into silent mode. Thank you very much. 各位來賓，我哋第二場嘅專題研討呢，馬上就會開始，有請各位盡快就座，並且將你哋嘅手提電話調至靜音模式。多謝合作。各位來賓，我們第二場的討論環節馬上就會開始，有請各位盡快入座，並把你們的手提電話調至靜音模式。謝謝大家。Hello, ladies and gentlemen. The second panel discussions will begin shortly, so please kindly be seated. Thank you very much. 各位來賓，我哋第二場嘅專題研討咧，馬上就會開始㗎啦。有請各位盡快就座。各位來賓，我們第二場的討論環節馬上就會開始，有請各位盡快入座。謝謝大家。Hello, ladies and gentlemen, welcome back. So here comes our second panel discussions on unleashing economic potential through secure transition law reforms in the Asia-Pacific regions. So already on stage, we have our moderator, Professor Anna Venaciano, Deputy Secretary General of UNITRA, and also our panelists include Mr. William Brady Watson, Senior Legal Officer at UNITRA, Mr. Alberto Niniot, General Counsel of the Asian Infrastructure Investment Bank, and also Professor Giuliano Castellano, Deputy Director of the Asian Institute of International Financial Law and Associate Professor at the University of Hong Kong. So just a gentle reminder that there will be a Q&A sessions afterwards. So you can scan the QR code on the screen, on your table, all around this hall to submit your questions. And for our online participants, the QR code should be displayed on the screen. And now without any further ado, should we all give a big round of applause and welcome our moderators and panelists. And now I'm going to pass over the stage to our moderator.
Thank you very much, Commissioner Koo Yan Chun, Secretary of Justice, Mr. Paul Lam, Excellencies, distinguished colleagues, ladies and gentlemen. Since it's the first time I take the floor today, allow me to express how delighted I am to participate in the Asia Pacific International Private Law Summit and to be here once again on behalf of UNIDROIT at the Hong Kong Legal Week, and to wholeheartedly thank the Department of Justice of the Special Administrative Region of Hong Kong, its secretary and the entire team for the invitation and for the excellent organization, as always. Now, the title of the panel is Unleashing the Economic Potential Through Secure Transactions Reform in the Asia-Pacific region. And we are very fortunate to have excellent speakers. As the previous moderator, I have to say that I will not give justice to their very distinguished CVs. I will only introduce them very briefly, but you can find them in the materials of the conference. I just two words about the topic, which is actually focusing on access to credit. As the Secretary General of UNIDROIT has already said, access to credit is one of the traditional most successful areas of work of UNIDROIT. Many instruments of UNIDROIT have at least some elements relating to investment and access to finance. And we have already heard about the VCCs, for example, and later on of investment contracts. But there are some key instruments that are really focusing on secured transactions in various ways, including small to medium enterprises, and including also the already cited Cape Town Convention and its protocols to facilitate financing of high-value mobile equipment in key markets, as well as the newly adopted model laws on factoring and warehouse receipts. But I will stop here because we will start with my colleague, William Bridie Watson, who is Senior Legal Officer at UNIDROIT, and he's also the co-director of the newly established Asian Transnational Law Center at UNIDROIT, who will introduce the benefits of the Cape Town Convention protocols in facilitating cross-border trade and investment with a focus on the work done by UNIDROIT in this sector. So, Will, you have the floor. I know that you have a set of slides. So 15 minutes for you in order to allow for a discussion afterwards. Thank you.
Wonderful. Good morning, distinguished delegates, ladies and gentlemen. It is an immense honour to be here to speak at this second Asia Pacific International Private Law Summit and to be here in Hong Kong. And I reiterate the comments by the Secretary General and Deputy Secretary General, and our thanks to the Department of Justice for facilitating our UNIDROIT's participation in this important annual or biannual event. So this morning I have an easy job because I will be introducing one of UNIDROIT's most successful international treaties, and indeed one of the most successful international commercial law treaties ever negotiated, the Cape Town Convention. And I will be discussing in particular three of its protocols, the aircraft, rail and MAC protocols. So this is not UNIDROIT's only work in the field of access to credit. UNIDROIT has a long history since indeed the 1980s, developing both hard law treaties and soft law instruments in the field of access to credit, including in the fields of leasing, factoring, and agricultural finance. But my colleagues and my co-panelists will be speaking on some of these other instruments today, so I will just focus on our work in the field of asset-based finance, and in particular, the Cape Town Convention. So when introducing an international instrument, I always like to start with the problem, the legal problem that arose that the international instrument was designed to fix. So in the 1990s, you had a wave of privatization, particularly in the aviation sector. You had public airlines becoming private airlines. You had the need to refresh aviation fleets to meet new safety standards. And this, of course, required a lot of finance. Aircraft are very high-value assets, usually cost more than 100 million per asset. They travel across borders, and this was creating a significant legal problem and financial risk for creditors, because when you have a large-scale default or insolvency event for an airline, which happened, I am Australian, which happened in Australia in 2001 when Ansett Australia became insolvent with 130 aircraft scattered around the Asia-Pacific region. The applicable law at that time was usually lex situs. Wherever the plane was at the point of default or insolvency was the law that applied to who had priority over that aircraft. And this created huge legal risk for creditors. The uncertainty created by the lack of common understanding of the applicable law meant that creditors were unwilling to finance the acquisition of new aircraft or would finance them at very high costs. And because of this gap in the international legal framework, UNIDROIT was asked to create an international treaty to deal with this problem. And the solution was indeed the Cape Town Convention. So on a very basic basis, the Cape Town creates more certainty by creating harmonised uniform legal rules for the financing of high-value mobile assets. It creates more certainty in investment decisions by creditors. It lowers risks and thereby lowers costs. And this creates, on an economic basis, additional investment opportunities and the availability of cheaper credit. At UNIDROIT, we love this map. This map is the map of contracting states to the Cape Town Convention. As you see, we have 87 contracting states in green. The yellow states are those that have signed the protocol but have not yet, the convention, but have not yet ratified it. This makes it one of the most successful international commercial law treaties in history. The Cape Town Convention has a unique structure where you have the Mother Convention itself, and then the rules in the Mother Convention are applied to different sectors through asset-specific protocols. So you have the Aircraft Protocol in 2001, the initial protocol, the Railway Rolling Stock Protocol in 2007, the Space Assets Protocol in 2012, and the Mining, Agriculture and Construction, or MAC Protocol, the most recent protocol, in 2019. And each of these protocols actually control the content of the Mother Convention to tailor their rules to the specificities of the financing in relation to those particular assets. Because, of course, financing a plane is very different to financing a satellite, and also very different to financing a tractor or a crane. So ultimately, the protocols have to change, alter the rules in the Mother Convention. Without going into great detail, there are a few key rules at the heart of the Cape Town Convention. And the most important aspect itself is the creation of the notion of an international interest. An international interest, which is created through either a security agreement, a conditional sale, or a lease agreement, where the debtor in that agreement is located in a state that has ratified the protocol. If you have one of these types of agreements in an asset covered by the protocol, and the debtor is located in a state that has ratified the protocol, you can create an international interest. Once you have an international interest, you can register it in an international online electronic registry. There are different registries for each protocol. So there is a registry for aviation equipment, a registry for railway equipment, a registry, and there will be registries for MAC and eventually space equipment as well. Once you have registered your international interest, you have protection around the world for your interest in that equipment. You have priority over unregistered interests, you have priority over later registered interests, and you have priority over domestic interests arising from domestic law. So this concept of an international interest gives you almost a super priority, a super protection that applies around the world and gives creditors great comfort and great legal certainty in financing the assets covered by the Cape Town Convention and its protocols. And just as importantly is that the convention and the protocols themselves provide remedies for the creditor on default and in most circumstances also on insolvency. So where you have an international interest in a plane that's registered and you have a default on that security agreement or on that lease, the convention itself provides what you can do. You can repossess the asset. You can resell, you can release the asset. You can export the asset from particular territory. And these concrete remedies, again, provides additional security and certainty for creditors under the treaty system. The aircraft protocol was the first protocol, the most successful protocol. It has 84 contracting states around the world, over 1.5 million registrations of interests in the aviation registry, which shows that it's not just a theoretical success, it has a practical success. And it's been so successful that the OECD has negotiated what's called the Cape Town discount for export credits, which means that if an aviation company in a contracting state that has made certain declarations, then they can access a 10% discount on the cost of export credit for financing of new aircraft. And again, this is not a theoretical legal benefit. This is a concrete, real-life benefit that has provided economic advantages to contracting states around the world. Here you see that on a standard wide-body aircraft worth $140 million, you could have export credit savings of up to $1.3 million and even capital market discounts of up to $6 million based on ratifying the convention. And again, here you see airline debt issuances. The blue line going up is countries that have ratified the convention and the aircraft protocol, whereas the grey line is countries that have not ratified the protocol. And you can see that there's been a large increase in the expansion of access to credit in countries that have ratified the protocol as compared to those that have not. This year was a momentous year for the Cape Town Convention because it experienced the entry into force of the second protocol, the Railway Protocol, which was negotiated in 2007, but is now operational since March this year. The Rail Protocol has great potential to attract more private sector lenders and lessors into the railway market for both passenger and freight, resulting in cheaper finance for operations and wider choice and operator flexibility. The protocol will foster economic and social development by enhancing sustainable mass transportation of people and will facilitate greener technology and support the UN Global Sustainable Development Goals. Most importantly, by providing better security in the railway rolling stock, in the trains that operate on these networks, it will allow governments to focus their investment on the infrastructure required for railway networks, which will allow for both private and public financing of railway rolling stock and will closely support the kind of important infrastructure investment undertaken by groups such as the AAIB. And of course, will support the development of international commercial networks such as the Belt and Road Initiative, and also the Rail Protocol provides for a new global system of unique identifiers for railway equipment because that didn't previously exist. Because the Railway Protocol has only been in force for a matter of months, we do not yet have ex-post data about its economic benefits, but we have received independent assessments of its likely impact once it becomes broadly ratified. As you can see from this slide, an independent assessment suggested that there could be up to $19.4 billion benefit if it's ratified across Europe, and up to 5 billion GDP pounds benefits in the UK, as well as a significant benefit for Africa. These same benefits would apply to Asia. We haven't had the economic assessments done, but there is the same kind of significant economic benefits that could arise across the Asia region. It's also important to note that the trains do not need to move cross borders in order for the treaty to be successful. In fact, many of the aircraft registered under the aircraft protocol operate within one country. They only operate on domestic routes, but they still benefit from the significant legal protections from the Cape Town Convention and thereby its economic beneficial effects. In my last 2 minutes, I want to discuss the Mining, Agriculture and Construction Protocol, the MAC protocol, the most recent. The global market for MAC equipment is huge, over $200 billion a year, but it is a market in which credit is particularly restricted, especially across developing countries. In many countries, there is very little access to credit for financing of high-value MAC equipment. The MAC protocol covers over $148 billion worth of high-value mining, agriculture and construction equipment. And because of the essential benefits that the mining, agriculture and construction sectors have for developing countries, it has been predicted to be the most economically important of the protocols for the Cape Town Convention if widely adopted. An independent economic assessment suggested that if it's widely implemented around the world, it will increase the deployment of MAC equipment by $90 billion over 10 years, and this could result in an increase in global GDP of $30 billion. 23 billion of that would be for developing countries, which makes perfect sense because developing countries tend to be more reliant on the mining, agriculture and construction sectors for their GDP as compared to the more advanced economies. This is particularly the case for the Asia-Pacific region. Here you see, based on the UN trade data we have in relation to this protocol, Asian manufacturers, Asian financiers, Asian banks will all benefit significantly from the MAC protocol. You see the largest exporters and importers of equipment in the scope of the treaty. China is both the second largest exporter and the second largest importer of MAC equipment within the scope of the treaty. This gives you a sense of the kind of transaction that would be facilitated and strengthened by the MAC protocol. You have a manufacturer in China, a financier in Hong Kong, and a construction company in Indonesia. If Indonesia has ratified the protocol and the convention as the debtor, it will apply. The financier in Hong Kong could create an international interest in that crane, creating a sale opportunity for the Chinese manufacturer. And even if that construction equipment then moves to another job in Malaysia and another job in the Philippines and is then even released but to a potentially a second construction company in Brunei, the international interest created by that Hong Kong financier would continue to apply throughout this entire international transaction. So my last slide. Where are we up to now? The Rail Protocol, as noted, has just entered into force. The registry is operational, so countries can now ratify the treaty and take advantage of its legal and financial rules. You see the 4 states that have currently ratified it. We are strongly promoting its economic benefits in Asia. The MAC Protocol, because it's newer, has not yet entered into force. We have our 5 signatory states, but we need 5 ratifications. The registry is currently being built, and the expectation is that it will enter into force in the very near future. UNIDROIT is working very closely with APEC and the APEC Economic Committee in promoting the implementation of the Cape Town Convention and its protocols in the Asia-Pacific region, as we believe it will provide significant legal and economic benefits, as well as to the important legal and financial community here in Hong Kong. Thank you very much for your time.
Thank you very much, Will, for providing this overview, but actually also with quite a lot of very important details on the Cape Town Convention treaty system, in a way, and particularly the two protocols which are now coming to the fore, which are the rail and the MAC protocol, but also underline the importance of the Cape Town Convention in general and aircraft protocol, to which the People's Republic of China is a party, and we hope that this can be also extended to the Hong Kong Special Administration region. So thank you very much. And now I will pass the floor to Alberto Nenio, who is General Counsel of the Asian Infrastructure Investment Bank, AIIB, with a very long and distinguished career in the bank itself, but also in the World Bank and other institutions. He is therefore in the best position to speak about the challenges and opportunities for multilateral development banks in private sector development in Asia, in particular, the legal and institutional aspects. So Alberto, you have the floor. Thank you very much.
Thank you very much, Professor Ana Veneziano, colleagues from the panel, DOJ colleagues, always young colleague, Ignacio Tirado. You know, I need to know your secret. Maybe it's Rome. I don't know. But very good to see you again. I could not really think but have a little bit of a jealous when William was talking about, you know, the prerogatives and the very well-crafted system that the Cape Town, Convention provides. Because we, in the multilateral development banking world, we have a concept of preferred credit status. And preferred credit status, we only know when it happens, but there is no registry. So everyone runs for the money, basically, especially because we have a multitude of international financial institutions. So congratulations to you and, UNITROA under Ignacio's leadership for putting this together. Obviously, it was not a very easy undertaking, and it's still an ongoing project. But ladies and gentlemen, I'm here today to talk a little bit about, how the system benefits and also provides, some input for the secure transactions. As AIIB and before with my old organization, the World Bank, we both invest in public and private sector projects. AIIB is the newest of the multilateral development bank. It's going to complete 10 years next year. And we are a combination of a private sector and public sector. And if you are familiar with the World Bank system, we are World Bank and IFC all wrapped up together. So it is a real pleasure to talk about something that is very close to our hearts. We do not finance projects in which we do not find the conditions in which we can make that investment. It doesn't have to be perfect. We now have 110 countries part of MDB or the AIIB, and it is the second largest multilateral development bank just after the World Bank. So I'd like to shed some light on the unique position of AIIB as both as a promoter but also as a beneficiary of projects that can benefit from this very, very singular approach, to secure transactions. So as we finance countries and as we finance private sector investors, we want to make sure that the basic conditions are there. Some of the basic conditions, and so one very important condition we just heard, from William. So we are also governed by international treaties, including the Articles of Agreement and what we call other basic documents, and they hold a very special status. These documents, along with principles of international law, grant AIIB certain privileges and immunities, enabling it to play a role in promoting law reforms and to facilitate economic growth in its members. Again, the existing domestic legal framework doesn't have to be perfect, but has to be sufficient to allow us to make an investment. So today I'd like to highlight some of the opportunities and challenges that we face. Originally in Asia, 57 countries, put together their efforts and their capital to form AIIB. And as I said, now we are 110. It is the only regional IFI, or only regional multilateral development bank that today has a very unique situation. We have more non-regional countries than regional countries. So that, to make it work, is tricky and interesting at the same time. So firstly, some of the opportunities or some of the advantages. The first opportunity that we have is that we have a very good rapport and collaboration with regulatory agencies. We talk with regulatory agencies from across the globe, Hong Kong included, but also regulatory agencies that are not members of AIIB, not country members, including the US and Japan, which are countries that we raise resources. AIIB constantly issue bonds both in the US and the Japanese market, and we have a standing registration with the US Security and Exchange Commission. So this collaboration, in order to better understand where the regulatory landscape is going, but also to make a contribution as we do, for example, the basic protocols and conventions, afford us an opportunity to be part of the game, but also to benefit, from that relationship. The second area that I want to mention, which I believe is the bedrock from the financing in the private sector today, particularly with a very volatile exchange rate, is the ability to invest in local currencies. We are now investing in all major local currencies that we have projects. We are expanding on that, and we have a very successful Panda bond program in China mainland. So borrowers, when they come to us, both private sector and public sector, they look for the best conditions, for the best way that they can maximize, their investment. So local currency is something interesting, but at the same time, very challenging, and AIB is very committed to do that. The other part that AIB places special consideration, it's what we call, some people call it soft, we call it, ultra important, which is the environmental, social, governance, and procurement aspects of our investments. We are not a regular, traditional commercial bank or investment bank. They have their role in the system, but we like to push the envelope in terms of values that we feel that they are important. And those values, they have been approved by our board of directors. Again, 12 directors representing 110 countries who felt that we should have certain environmental, social, governance values in the way that we invest. So every project that we finance has to have a set of minimum principles and conditions in which it may make sense for us to finance, but at the same time, we will uphold not only the value of that investment, but also the reputation of the bank as a whole. So the final point I want to make, it's about upholding privileges and immunities. This gives us a very unique ability to operate free from the courts, but also following the rule of law. And how do we do that? By choosing the domestic law that is applicable, but also choosing arbitration that is applicable. We are revisiting this issue. We just had a very good conversation with Secretary Paul Lam, to see what kind of other jurisdictions we can take into account and particularly expand arbitration. I know that UNCITRAL has a very active program and contribution on arbitration as well. I'd like to now touch on a few of the challenges that we are facing. We heard today from the distinguished speakers that open up the conference today about the geopolitical challenges that we are all facing, which I think we all can agree is not for the benefit of any of the countries involved. But at the same time, one of the areas that we have to navigate is to navigate the sanctions landscape. And it has not been easy for international financing. For a multilateral development bank, we do focus and we have to uphold the UN Security Council sanctions, nothing else. But at the same time, when you raise resources in a domestic jurisdiction, be that in the EU or in the United States, you also need to at least observe that you're not going to be violating those sanctions. That's tricky, that's complex, but at the same time, it is the real politic that we are facing. And we hope that the main elements of those political landscapes can be abbreviated soon. So I know it's a note of optimism, but I can tell you that it makes the lives of international finance very, very complex. The second point that I want to mention is the issue of governance and the fight against fraud and corruption. The investment that we make has to be upholding the highest principles of integrity. And as we are no police, we really count on the domestic systems to pick up the issues that may compromise the integrity of the international resources that we put available. So I highlighted two of these points. I think these are some of the things that we look into as opportunities and challenges when we invest. We are very much focused on building a robust international system that upholds the principle of environment, social governance, but at the same time that would allow us to make investments that at the end of the day will promote prosperity to all. Thank you very much.
Thank you very much, Alberto, for the insights in the impact that, generally speaking, multilateral development banks, but particularly the AIIB, can have and are having and can have also in the future in reforms of domestic laws in the direction of promoting growth and investment, but also you mentioned, and it's important, sustainable growth and development. And this is exactly what we will be discussing also in later panels today. So it's a good link to other discussions. And I also think that the next presentation is an excellent segue to what Alberto has introduced, because Professor Giuliano Castellano, who is Deputy Director of the Asian Institute of International Financial Law, and he's an Associate Professor at the University of Hong Kong, he will talk about the legal and regulatory complementarities for supply chain finance, and he will focus in particular, using it as an example, on the UNIDROIT model on factoring and the IFC knowledge guide on factoring regulation and supervision. So Giuliano, you have the floor.
Thank you very much. I use this chance to, first of all, thank you heartwarmly the Hong Kong Government Department of Justice for organizing this fantastic event, now becoming flagship, and as we heard, is going to become something known international. I also really want to thank my friends and colleagues from UNIDROIT. It's always a pleasure to see them here, especially Secretary General, Deputy Secretary General, and of course Will and Mei Ling, which are now part of this international family. Without further ado, I actually dig into this area of how to implement international standards, right? So let's say that I had the privilege of serving both as one of the members of the drafting committees for UNIDROIT and for UNCITRAL on their flagship instrument to support some of the flagship instrument list to support access to credit. The UNCITRAL model loan secure transactions, which is fairly broad, large instrument, and the UNIDROIT model law on factoring under the, let's say, guidance and stewardship of Will, which I thank again for his patience to keep it keep us all, working well and smoothly. So these two instruments, so this is one part of what I've been doing and what I've been observing together and learning, especially with other more, let's say, knowledgeable colleagues from all over the world. The other side, I've been actually involved in a series of law reforms, implementing these standards. And as an academic, connecting these two areas, connecting the drafting of rules with the implementation on the ground, actually opened to me a whole different dimension. And so what I want to focus on in particular today is how this type of connection between the drafting of the rules, its implementation, effectively can deliver access to credit for small and medium enterprises around the world. Now, first and foremost, we know that, unfortunately, any type of international standard cannot be implemented in a vacuum. It's not something that is a plug and play or copy and paste instrument. And this is not me saying or discovering it. It's something well known, and well known especially also by UNIDRA and UNCITRAL, that in fact do offer different options already in the type of rules that can be implemented, and there are a series of implementing guides in order to explain how these instruments can be adapted to local needs, economic and legal needs. But there is something new that is emerging and is been starting. We heard that from the very beginning of this event. We heard that with the previous panel, and we heard it actually very right now from my colleague that actually in this panel pointed out the importance of regulatory coordination. So why regulation is becoming more important? Well, first, there is a general trend, right? After a series of different type of crises, starting from the late 90s Asian crisis, then the global financial crisis, there is a series, it's quite understood that a sound and proportionate regulatory system is necessary to promote financial development, financial independence, and as well as access to credit. That became quite obvious. But more recently, COVID-19, it showed us that to avoid that a health emergency became a fully fledged financial crisis, well, the regulators became critical. Regulators, of course, together with Ministry of Finance, together with Ministry of Justice, that actually they were putting some controls on the enforceability of different rules. But regulatory systems implementing exceptional rules have been fundamental. Even more, with dealing with digital assets. Digital assets are increasingly becoming regulated. They are regulated activity. So we heard from the MA specifically what is the Hong Kong Monetary Authority, specifically what are the intention to actually the approach to these different regulated activity. So we're not only trying to establish a property right of a new asset, which is extremely important, as we heard from Professor Lowe, but we are also establishing a property right on a regulated activity. We change the type of dynamics. Finally, we do have, the push towards green finance sustainability is actually now tasked to the regulators. The regulators, banking regulators in particular, and central bank, often within the same roof, but even when they're not, they are increasingly more tasked to take care of a broader range of issues. In particular, access to credit and factoring or supply chain finance reforms are often led by regulatory authorities. So the point here is not so much, how can we make rules not completely work in a vacuum, but actually is really how can we coordinate, how can we create a cohesive system that actually where legal rules, regulatory approach go towards the same direction by following their own independent policy objective, and that's absolutely fine. How to do that? Well, let me take the example of supply chain finance, in particular factoring. So factoring, intended more broadly as the possibility to establish, to transfer payment rights is actually fundamental for the growth of the economy. Small and medium enterprises do have primarily these type of payment rights that they can transfer, invoices. And in turn, if a small and medium enterprise has invoice, is a good flag, is a good sign that actually the business is healthy because they have clients. So taking these assets as collateral or selling them is a fundamental to actually to promote access to credit, and even more, to link this type of business to the global supply and value chain. It can be also local supply and value chain. But in either, it's the only possibility to scale up. So here we have two issues. Well, first of all, the UniDRA model law on factoring creates a legal framework broad enough to include a variety of products and provide a set of private law rules that will govern in a very, the optimal way, the relationship between the party, the certainty, the priority, and even actually more sophisticated aspect in case, for instance, of international factoring and international private law rules. But here, when we go to the ground, when I come myself to actually to see how these rules are implemented, we find two main challenges. Challenge one, we do have a problem of coordination with banking regulation. Assets, I'm not going into too much details, but let's just say that under normal circumstances, transactions that are considered secured under private law with these type of intangible assets are treated as unsecured under prudential regulation of a given jurisdiction. So we go far and so far to ensure that actually that with the risk lending to small and medium enterprises, but then we still have a regulatory system that might be old-fashioned or established in a way that doesn't fully recognize this de-risking ability. The other problem that we have also with regulation is that, for instance, the definition of factoring, right? You know, the model loan secure transaction and then even more the factoring model law of UniDRA adopt a very large definition of factoring. Actually, in fact, the UniDRA model law doesn't define factoring at all, and is a policy choice because the idea is to include a series of transfer of receivables, no matter how they're made. And so there is no confusion with that and allows the development of a cohesive system where even data transaction, receivable arising from data transaction or IP can be used to develop different kind of products. But when we look at the regulatory definitions, for instance, for even non-banking financial institutions, on what they needed for having a license, we often find a very restricted notion of factoring, which is the purchase of receivable arising from goods and services. So we don't have, for instance, the possibility to use receivable as collateral, not a purchase, or to consider IP, right, intellectual property, receivable arising from intellectual property, royalties as such, or we don't have the possibility to use data transactions, and so on and so forth. So this type of system creates some restriction, and so creates some uncertainty in the market, because the idea is like, why can I develop one product with this license and not another? So the second, well, there is another element, of course. If we add the technology to it, we have another layer of complexity, because what kind of, how do we treat the receivables that, for instance, are arising from other types of digital assets, and so on and so forth. So in this situation, we do need to create some coordination. We're not saying that regulators should change their policy or not, but we're simply saying that we need to ensure that the industry, that on the ground, the people know very clearly how a certain type of asset, whether digital, whether non-digital, whether provided as in a different type of product to promote access to credit, is or is not regulated. That's essentially the point. Wherever we have the gray area, we have a problem. And this is also precisely why the ambition that we heard, for instance, that has been enacted, for instance, today from Secretary Lam, is to create legal certainty in Hong Kong in order to attract different type of investment, including in this area. So this is why, and here I reach towards what is the conclusion or the main point I'm trying to raise. So first of all, coordination is extremely important. It's extremely important at the international level when international standards are drafted, and UNIDRA in this regard for the model law factoring, I think is an example. And not surely for my merit, but because actually it reached out, for instance, to the World Bank and in particular the International Financial Corporation to coordinate in the drafting of some guidance for the regulatory framework for factoring. This is a non-bank type of financial institution, so it doesn't fall under the premise or the remit of the Bank for International Settlement, but actually we do have, especially with the World Bank, lots of experience at the domestic level on how to coordinate something like the model loan factoring with existing regulatory standards in order to ensure access to credit and financial stability. Now, this is a fantastic approach because, as the Secretary General reminded us at the very beginning, UNIDRA is focused on private law rules, but it doesn't mean that it's not cooperating with regulators. And in fact, this is a possible way to maintain these autonomy and mandates, and has been enacted in the context of the model loan factoring. So the second element, so my hope here is that other international organizations will take that as part of their methodology to develop international legal standards, coordination, communication with regulators at the very early stages. The second prong actually connects with how we implement these rules domestically. We need a methodology. We need an approach more than actually more standards. Methodology that, for instance, we've been using and have been also presenting here in Hong Kong with a series of initiatives within APEC and in particular the Business Advisory Committee, to start from developing a product and then make the different type of legal and regulatory reforms. So in many jurisdictions, we do have rules that are quite functioning. Instead of actually going and changing everything from scratch, like implementing a very large type of reform, instruments like the UNIDRA model loan factoring allow us to have product-focused reform. Product-focused reforms are essentially reforms that are focused on enabling a family of products based on what are the effective needs of a given economy. An economy like Hong Kong, for instance, that is pushing for promoting digital and green economy, might focus on different products of another economy in the region that might be more focused on a certain type of agricultural finance. And therefore, by actually having this knowledge, by doing this type of diagnostic, and then ultimately having the guidance from international standards, reform can be better tailored, implementing international standard, and ensuring coordination with regulatory matters at the domestic level. Thank you very much. I stop here.
Thank you very much, Giuliano, for your contribution, which puts together both your expertise as a member of the working group on factoring, on the factoring model law, and therefore the private and commercial law aspects of it, and your expertise in regulatory matters. So thanks to the fact that our speakers were really excellent in keeping time, I think we might have a little bit of time for questions. And we already received quite a lot through this excellent system that is organized here. Allow me to put only two of them, otherwise we will run out of time, and I know that you're looking forward to your lunch. So I have a more specific question on the MAC protocol for Will, I suppose, and then a more general question for all of you who would like to intervene on the cooperation and collaboration of the different organizations in this particular field. So, Will, there is a question on the what types of assets are actually covered by the MAC protocol, and in particular whether, for example, a motor vehicle would be a part of it or not. So could you please address this question?
Thank you very much, Anna, and that's a very good question. I didn't want to go into the depths of the long process we went to identify the types of equipment that would be covered by the MAC protocol. The reason it's such a good question is this issue was one of the most difficult parts to overcome in negotiating this international treaty, because the Cape Town Convention is designed to finance high-value commercially used equipment, aircraft, trains, satellites, large-scale construction equipment. It's not designed to facilitate finance for the family's lawnmower or low-value personal use equipment. It's a completely inappropriate instrument to finance this type of equipment. So the mechanism in the MAC protocol that defines the type of equipment it covers is harmonized system codes. Trade lawyers in the room will be familiar with these codes. They're a series of over 5,000 six-digit codes defined by the World Customs Organization that are used to regulate international trade, negotiation of tariff agreements, etc. And they provide very specific definitions of different types of equipment. And we were able to utilize these codes and identify 54 codes that cover primarily high-value mining, agriculture, and construction equipment. Now, 54 codes doesn't sound like many, but these 54 codes actually cover $148 billion worth of equipment exported internationally every year. So it is a very large volume of equipment covered. And by using these codes, we were able to avoid covering things like motor vehicles or low-value shovels, spades, lawnmowers, etc. So that's how, this is a unique feature to the MAC protocol. The other protocols to the Cape Town Convention have a definition. They define railway, rolling stock, aircraft, space assets. But the MAC protocol had to utilize this special feature, which is also beneficial because it allows us to potentially expand the scope of the treaty in the future when new technologies are developed and designed and new HS codes come into effect. I hope that answers the question. Thank you.
Thank you very much, Will. And very last question, the more general one. So how can intergovernmental organizations, development banks, other bodies cooperate and work together and also bridging the gap between the public and private sector, particularly in the field of secure transactions that we are now discussing, and the implementation of international standards. So perhaps we can start with Alberto.
Thank you very much, Professor Veneziano. And with Giuliano's kind permission, I think we all agree in the MDB world that is highly deficient. We need to improve that kind of collaboration. And I think we need to start moving into a more formal forum, in order, almost like starting with a clearinghouse, in order to move forward and having a more effective collaboration. And also one thing that since I moved to Asia that I missed is that you have different kinds of systems and more organized systems in North America and in Europe. We need to move and focus on Asia now. And I think AIIB and others will really stand ready to collaborate on that. But we feel that that kind of exchange and clearinghouse is very important as a first step.
Thank you, Giuliano.
Thank you very much. Yes, well, I think this connects very well to what we heard at the beginning, like the need that to change, to reform the economic order in general. But, you know, this actually ties in our work to actually a new order for rulemaking, where coordination is embedded, where actually the problems are looked not only on one angle, but actually from different angles, and then how they are effectively applied. And the second thing, a new approach to reform. So meaning like, you know, legal change actually happen incrementally with market change. If we can learn one thing from the experience of China, is that actually reforms take time, needs to be steady, and needs to actually to grow together with market. We cannot start with law first or market first. We need to grow together. And that can be implemented in a new reform approach and a new approach to rulemaking.
Thank you very much. So thank you also for focusing on the fact that there should be fora where this cooperation is enhanced. One of them could be also the conference on secure transaction cooperation as among and between different intergovernmental and international organizations, which is held every year. But this should be further implemented. Could you allow me, please, to break perhaps the protocol and give the floor to the Secretary General, who has raised his hand in a more traditional way, if there is 1 second to do that?
Sorry, I didn't realize I was breaking the protocol. I didn't mean to. No, in Alberto's speech at the beginning, when he mentioned the priority normally given to multilateral institutions that provide credit, in some cases based on a lender of last resort position, in other cases because it's just widely accepted as such, although it's not necessarily written anywhere. I'm not sure that's anything other than fully compatible with strengthening the secure transactions legal system in those countries where you are building the infrastructures, because you might be providing the great scheme of the, perhaps based on a project finance scheme, but then that would be to build the infrastructures. But what Cape Town does is provide financing to fill those infrastructures with rails, with rolling stock material, with MAC equipment. So it's fully complementary with machinery that will allow for the construction of the roads you're financing. So it's, let's say, your activity and your priority is completely complementary with the benefits that Cape Town would bring to the countries where you take your activity in that sense. I don't know if you agree, but that was my impression.
Thank you very much. So we would have actually quite a lot of other questions, including also a question, for example, on the space industry and the fact that one of the protocols is actually focusing on space assets and therefore looks into the future on a very growing market. But perhaps if you allow me to do so, I will close here our panel and join me, please, in thanking our wonderful speakers for these excellent panels and the insights. They will be available for questions. I'm putting them to the fore for the other questions for the future. Thank you very much.
Thank you very much, our moderator and speakers. So please remain seated first and let's have a good photos. So please kindly look at our official photographer in the center for good photos. Thank you very much for the wonderful presentations by our speakers and the enlightening discussions. All right, thank you very much, our moderator and speakers. So please kindly exit the stage and be seated off stage. So ladies and gentlemen, we're going to have a lunch break right now, and the afternoon sessions will resume at 2 p.m. with our third panel discussions. And for our online participants, we will see you at 2 p.m. So please kindly return to the conference venue at 1:55 so we can start on time. Please make sure to take all your personal belongings when you leave. Also, if you intend to claim CPD or ALE points for the summit, please remember to sign out at the reception and sign in again after lunch. So thank you very much, and I'll see you back here at 2 p.m.